All right, you may proceed, Mr. Brown.
People usually leave after I start, not before. May it please the court. My name is David Brown. I'm here representing John Doe in this ethics case. We haven't had an ethics trial. We haven't had an ethics decision. The case is still pretty preliminary, and I appreciate the fact that the court took this on
In that regard, why is it taking so long to get this thing done?
Well, let me help you the best I can. I don't know. I'm not the prosecutor. I didn't work with Mr. Harrington. I don't work with Mr. Harms. I do know this, factually, what we know. Again, this is kind of guess where my knowledge base kind of begins and maybe ends. I know when there was an inquiry made by a member of the public relating to my client, and that was in 2013. And again, as is normal course, and it wasn't debated, we had contact, I did personally, with Mr. Harrington, that we have this complaint. We want to have a response to it. We want it to be complete. We want it to be, as detailed as possible. And he did what Charlie Harrington always did. He gave some additional time. And in 2013, I think it was in the spring, we went ahead and filed a 38-page response to the complaint and provided some additional documents. That's usually what the process is, at least where I'm sitting. I'm not the prosecutor. I don't know how they determine it when it goes to the Board of Ethics. I think the ethics prosecutor, I think I'm right on this, presents things to the Iowa Supreme Court Board of Ethics. I wasn't invited to that. But in any event, there was a request for additional material in 2013. We responded to that and provided a lot of documents. Again, I would have assumed, Justice Wiggins, we're going to know either they dismiss it, it's nothing, it's a private admonition, they want a public reprimand, they want to send it to grievance, they want something to happen. And I'm awaiting whatever decision they're going to make. Wrong. We go to 2014. They want more information. We did what you would anticipate we should. We're licensed lawyers. I call Charlie. I visit with him. What is it we believe we need? We'll provide it. We provide some more information. I think we did it twice in 2014. I have, at that point, no idea whether this is a live round or that the insatiable appetite for information has been satisfied. Finally, in September of 2015, there's a 392-paragraph complaint, and there you are, 38 pages of whatever, and that's the beginning of a formal grievance.
And our rule...
So what happened in 2.5 years, I would have no clue.
The rule itself, just reading from it, and you're familiar with it, of course, our Rule 36.7 says that if the respondent fails to file an answer within a time specified, 20 days, the complaint shall be considered admitted. It seems, at least currently, the board's position is that should be taken literally. That was the position of the commission, I guess. It says shall be deemed admitted, mandatory duty. What is it about the language of the rule that suggests that the rule can be waived by the board? Well, anyway, why don't you explain how you get outside the mandatory duty, which says shall be filed within 20 days, unless upon written application?
Well, I don't think we're getting outside the rule in terms of responding to your question, which is what I'm going to attempt to do. That's a directory statute. That's not mandatory.
Well, but directory statutes...
If I could help you a little bit more. Yeah. I think Justice Wiggins in the Doe case in 2008 went through the difference between directory and mandatory statutes as it relates to grievance proceedings. And this rule is much like that. It's not, there has been no adjudication on the merits. we have represented counsel. There's communication between counsel and the ethics people. It's understood. Wendell, in his brief, acknowledges he and I had such conversations. Issue was never an issue either with the prior rule, which relates to the initial complaint being filed, and of course there's a provision if a lawyer doesn't respond within a what period of time, the ethics people can present to this court, and with a 10-day notice, you can suspend somebody. So I'm aware of that. We're all aware of
But
that.
why
But in
didn't
terms of the communication back and forth
Why
with
didn't you file an extension? I mean, the rule says file an extension if you want more than 20 days.
Well, I'll attempt to respond to that too. I've been interacting with this board, I should say board's counsel, for 25 years. We call them, we get extensions informally. It's done literally all the time. Actually, when Wendell filed a motion for a definitive deadline, what he's saying is, I just want a definitive date when he's filing the answer. I think he was, I was going to assume he was as surprised as I was when we got the ruling from the board chair. I noticed he changed midstream once we got a ruling, and then he resisted our motion for reconsideration. But the fact is, that's done all the time.
Can we allow attorney practice to circumvent a rule?
It happens in about every rule that I'm aware of, except the statute of limitations and a notice of appeal to this court. I mean, the fact is, if you can't count on the word of opposing counsel as to how things are going to be handled, and they're handled that way every single day in every single courthouse in the state, I think we've moved into a very distant past. I mean, I read an opinion Friday with interest. Since I know Mike Riley, I understand the kind of lawyer Mike Riley is, and I understand Mike Riley now has an opportunity to practice again. But here's somebody who's been disbarred, and he's given every procedural benefit to come back, and we're saying someone who's never had a hearing isn't going to be entitled to basically be able to protect and proceed on the merits. And as we also pointed out, the individual, this individual
Mike
is
Riley
sick.
followed the rules, Mr. Brown. He filed his application. He did what he was supposed to do in a timely manner.
Well, just so we're real clear, I believe we followed the rules. And as far as interacting with counsel for the board, if you can't count on the word of the board people on the other side.
In the record,
Brown,
what in the record? I mean, I've looked at the record with some care, and you've looked at it with, I trust, great care. Tell me specifically what in the record there is about an agreement between you and Mr. Harrington. I mean, I've looked at the course of the communications. Sure. I've looked at the fact that you supplied on a couple occasions, 3 occasions, I think, additional information. I have looked at the motions that were filed and so forth. And I understand all that. What I did not see in the record is any evidence of a specific agreement between you and Mr. Harrington or anybody at the board. I have the course of conduct, and I understand that. Sure. But I didn't see any record testimony about a specific agreement. Tell me that I'm wrong, if I am wrong, and point me to the specific part of the record I ought to be looking at.
Always glad to do that, but there's nothing in writing. I'm not suggesting there wasn't anything in writing, but I am.
Writing, what's in the record? Not only not in writing, I want to know what's in the record of this case that I can look to show that there was an oral agreement between you and Mr. Harrington, or anybody else, not to file an answer. I've looked and I haven't found it. I could be wrong, and that's
we had in our brief, and Mr. Prosecutor had in his brief. He acknowledged there were communications. He also acknowledged he and I had communications. The
content of the communication isn't there. That's the problem I'm having. The course of conduct is there, but nowhere in the record. And I'll ask you a third time: is there anywhere in the record that establishes the substance of an oral agreement between you and the board related to filing an answer?
There is no document. But
evidence.
I'm making a flat professional statement. That's exactly what happened between me and Mr. Harrington. That's also professionally what happened between me and Wendell. But the fact is, at the end, I don't think Wendell anticipated in 10,000 years that when we had this hearing to set a specific date and perhaps to reschedule it because of the health issues of my client, who's been in and out of hospitals and in and out of testing for months, which has been his primary focus, to be alive, I mean, as a human being.
Mr. Brown, let me ask you, the briefing talks about directory mandatory, but earlier you touched on something that strikes me as potentially relevant, and that is it jurisdictional? In other words, is this a deadline that can be waived or not? If it can be waived, then it strikes me you may well be in the ballpark. But if it is jurisdictional, you can't. And I think we talked about that distinction in MC Holdings. What's your position on that?
It's directory, it's not mandatory, it's not jurisdictional.
Coun-
And I don't believe that rule has ever been interpreted that way.
Were you ever given a drop-dead deadline? We need an answer by X date or you'll be defaulted.
Absolutely not. As a matter of fact, what I got, again, professional statement, it's not in the record per se, but I don't think Wendell would dispute it. He called, indicated he was going to make a motion to get a specific deadline to have an answer on file. I said, fine. John Doe has been ill. He's been in and out of hospitals. He hasn't really been able to focus on much of anything. You know that. It's never disputed. We have this little hearing, and bang. That's how the rule is interpreted. So it was my understanding, at least I certainly thought so, when we went to the hearing, we would get, quote, as you would say, Judge, a drop-dead date, and we'd go from there. I mean, the reality was their suggestion, well, we cooperated early on, even though a 2.5-year investigation before a charge is filed only on material we produced. And they couldn't have filed a complaint if we hadn't produced all those documents. So the suggestion that we weren't cooperating with board counsel is absolutely make-believe. The fact is we clearly did cooperate with them. The fact is, at this point, we just want the opportunity to present evidence relative to the merits of very serious complaints. But as far as the other issue that I did want to mention, it was pretty clear to Charlie, it was pretty clear to Wendell, and it was pretty clear all the way through. There were documents, if I could finish this thought, Judge, there were documents that actually were taken by the FBI related to a third-party indictment and charge of somebody else, not our clients, in Chicago. They just took the documents and took off. It took a very long time to get those documents back. Everybody knew that. And everybody knew, generally, Mr. Doe's health was a contributing factor to his inability to assist in his defense. So in terms of, did we have anything in writing? No. Was that my understanding? Yes. Do I believe if there had been a significant departure from that understanding, that we'd have an affidavit from Mr. Harrington showing up in this case? I certainly do. And I also know that when we got ready for argument, you notice there was a request, no oral argument needed. I mean, we don't need to answer any questions. Well, I think there's a lot of questions that need to be answered. Both I need to answer them and Wendell needs to answer them. The fact is, this is a breakdown that if this is the way things are going to go forward, where somebody is charged with serious offenses and attempts are made to respond, and when you say, how long has it taken? I don't know why the investigation took 2.5 years. I don't know why, basically, the rules changed in the middle part of the game. I have no idea.
How's that relevant to the issue here? I fail to see how, I mean, frankly, I see foot dragging on both sides here. I see months of delay on both sides. But the question here is the interpretation of Rule 36.7. I think the mandatory directory question is a fair question. I think Justice Mansfield's question is a fair question. Can it be waived, and if so, how? And so I think our focus ought to be on the meaning of that rule and then how it reflects back on the record that's been established.
Absolutely. And on the rule itself, and if I could finish, Judge, I know I'm over. We believe it's a directory statute. It's not mandatory, and it can be waived. And we believe, as far as prejudice, there's no prejudice to the board, the ethics people. None. It's a matter of getting a scheduling date and holding a hearing. And the reality I was having, and still I'm having, is you have a client who's in and out of hospitals, he's in and out of treatment centers, he's in and out of surgeries, and he's having a lot of issues, and we're suggesting that doesn't matter. Well, I would think in every other context it matters a lot. And that's exactly what was not debatable. It was never hidden from anybody all the way through the most recent time periods. So,
Thank you, Mr. Brown.
thanks, Judge.
Mr. Harms.
Counsel, if I could just ask you to address one topic at the outset. On this question about the distinction between mandatory and directory with respect to Rule 36.7, is there some reason why it's important in a professional disciplinary context to have this be a mandatory rule that is not present under general civil litigation context under the rules of civil procedure where before you take a default, you give notice and you have some protections in that context? Why should this be different in the professional context? And why is it important that the court view this as a mandatory kind of prescription?
Thank you. I think it is important for the court to consider this a mandatory rule and so declare in this case. I don't know that, I mean, to my understanding, the court has not addressed that specifically with regard to 36.7. These cases, once they're filed, and I understand there's concern, and you're looking at the person, I guess, that you should share that concern with about the time in which it took to get this case on file. But once the case is on file, the rules provide that the hearing can come on a very short notice, 60 to 90 days is what the rule provides. So and I think the court recognized that in writing the 36.7 the way they did, because they did not write it the way they wrote, one way the court wrote, or way the rule of civil procedure 1.303 exists. 1.303 says you have 20 days to answer, and then there's another whole set of rules, the 971 series, that address what to do if 1.303 is not adhered to. And in the typical civil calendar, domestic relations cases being somewhat different, I suppose, than garden variety civil cases or mortgage foreclosure cases, but you know, the time frames for when the case is going to go to trial is much more expansive in the rules of civil procedure, if you will, than they are in the attorney disciplinary rule. So I think I think there is a good reason for it to be mandatory because of the short time frames that the rules provide the cases to come on for hearing, and that's recognized in the way the rule is.
But Mr. Harms, the thing, as compared to a civil case, there's in a sense more at stake here because somebody's professional license is at stake in these cases, so doesn't that cut in the other direction? And even in a civil context, we normally require that sanctions and defaults and all those sorts of things be kind of proportional to the wrong that's been done, even if something happens at the last minute just before trial. My concern is the outcome here seems very disproportionate to what actually transpired, and it may be that that's required, but it just strikes me as very disproportionate and wasn't what you asked for, Ryan.
It is not what I asked for, but I'll say this: you know, the matter was proceeding with no answer, no motion for an extension of time. We're just out in the ether.
Yes, but
and
you
I'm
didn't
starting
move-
to have deadlines come up.
Well, but you didn't move to enforce the rule. You didn't move to enforce 36.7. I mean, it seems to me there's, just looking at the chronology, the paper flow and so forth, there's communication going back and forth. There's a 38-page letter. There's requests for additional production, documents are produced, so forth and so on. And then ultimately, you go before the board and try and get this case kind of rescheduled to get it moving along, et cetera, et cetera. But at that time, you don't seek to enforce the rule, and it seems like there's an implied waiver. I mean, you're not, if the rule is mandatory, you're not seeking to enforce it. You're seeking to get cooperation from the other side. You finally go to the commission, and you don't seek to enforce the rule, and then the commission comes up and enforces the rule, if you will.
Well, that's the beauty of going in the courtroom, I think. You know, it's a three-legged stool.
I know, but I guess to put a sharper point in my question is, isn't there something to an argument of an implied waiver here of this rule under all the circumstances?
Well, I certainly never agreed that we would never take action, be it default or seek to that the matter be moved forward some way. Was it an implied waiver? I'll say that I certainly was trying to work with Mr. Brown under the circumstances to the best of my ability. But I felt I was in quicksand. I was getting nowhere, and something needed to be done. I'll say this, that in answer to the question that hasn't been asked of me yet, but yes, I was surprised with the ruling that the commission president made in this case. But I don't make that, I wasn't surprised because the road that he chose is not a nice road, a good road, and a well-lit road. But in my experience, it's not a road that most commission presidents would take.
It seems to
But
me,
in this case, he took it.
it seems to me the board took a very casual attitude towards this rule, didn't require an answer, didn't wait for an extension, let it go on for an inordinate amount of time. Is that the approach the board takes when enforcing our rules? Especially this one? Do they require answers, or is it just, we'll work with the attorneys and we'll get to it when we get to it?
When to push? There's probably no one answer to that, and maybe this case is going to teach me to push at a different time, an earlier time than I did in this case.
Doesn't the rule require you to push right away and get your answer, and then work out the problems?
The way the commission
I hope
president,
the board is not making special deals with certain attorneys, and people who don't have attorneys a different deal, and enforcing this rule. That seems to be, back to the good old boy system down there.
I certainly do not adhere to the good old boy system. Now, whether people are going to characterize me that way, I guess, what can I say?
Well, let me ask
But-
this question, though. Is it fair to say that it's the practice of the board in disciplinary cases to accommodate counsel who call and say, hey, the rule says 36.7, it says 20 days. I need more time. You probably accommodate them routinely. Is that fair?
Yes? And
Counsel, if we set aside this default and allow the case to proceed to the merits, would the board be prejudiced, and if so, how?
The board would not be prejudiced.
Mr. Harms, I think what we're dealing with here is a decision by the commission, and not so much what's going on with the lawyers, although it seems like we normally expect to have a little more professional courtesy when we're dealing with lawyers. But don't you think the inquiry in this case has to be whether or not there's been an inquiry into the standard that the rule sets, and that there must be a failure or a refusal to file an answer, and that requires some inquiry into what is causing the inability to answer? And do we have that in this record?
Well, we certainly have a failure to answer.
No, I mean, we can apply a rule black and white. Oh, if you don't answer within 20 days, the case is over, issue's decided. Or do courts have to go a little bit deeper and say, what's going on in this case? Is there a failure? If the lawyer's been kidnapped and is taken out of the country and can't answer in 20 days, do we just apply the rule and say, I'm sorry? Or does the court need to make, or the commission need to make an inquiry into determine whether there is a refusal or whether there is a failure to answer?
Well, I think there certainly is a basis to talk about an inquiry, but the rule gives the answer of how that is to happen. The party who cannot answer, who is kidnapped or whatever they are, they're kidnapped, but they're supposed to file the rule contemplates that they file a motion and explain their circumstances. My client is held outside the country. My client is ill. My client is whatever the circumstances is. And with that, then, the commission can make that inquiry, and the board can pursue the inquiry. What you have here, obviously Mr. Brown and I were communicating, but as to the commission, they have nothing. They have silence. And the commission here ruled, You didn't answer. You haven't put us in a posture where we can understand what the circumstances are and waive the deadline, which the rule specifically permits. So, you know, who should initiate the steps to start the inquiry? Should the commission beg the lawyer, say, well, you're not doing anything, tell us why?
But why
the rule
should we
contemplates otherwise.
But why should we hold an attorney, this defendant or this lawyer to this standard when the board didn't press for an answer and let it go on for so long?
Well,
Because it was the commission's prerogative to do what they chose to do. You know, this is not a business where Mr. Brown and I, the rules are the rules, okay? So I can be castigated for this and that, and I accept that. But the commission then comes in and makes a ruling, which they have the prerogative to do, and the language of the rule supports it.
Well,
and they can say plague on both your houses.
Oh, well, listen.
And that's what I think is important to me, is that, you know, you're put in the unenviable position of defending what the president of this commission did, which was to enter the default and follow the rule. And to me, the more serious question is not whether we're going to act civilized with each other and have an implied waiver and give all these grace periods. It's, to me, the real issue is whether or not this commission, under the rules that we have, had the authority to go ahead and do this, whether you asked for it, whether you had an agreement, whether this, you know, it surprised you. You know, I think it's a little unfair to criticize you and the time limits and all these other things here when you didn't make the decision. It's whether the president of the commission had the authority to do this under the circumstances. And all these other agreements that are there, I don't know how you're supposed to defend that one way or the other. Of course you're going to accommodate people, but it's really more of a commentary than a question. I apologize for that. But the rule provides that he can do that, correct?
Yes, that's the board's position, that the commission president is within the scope, within the language of the rule, the scope of the rule, when he made the decision that he made.
Thank you, counsel.
Thank you.
Mr. Brown.
If I could respond to that. The reality is, when we were at this unfortunately unreported hearing, which I wish it had been reported, I think we all do, but the reality was, Wendell didn't say, oh, by the way, this thing's been going on since 2013, and oh, by the way, they produced thousands of pages of documents, and oh, by the way...
I don't expect him to do that. The complaint
was
filed in September, and you have 20 days to respond.
Yeah,
I mean,
well, I would have...
That's what the rule provides. He doesn't have to go through all the negotiations and all the exchange of information that's occurred in the last year and a half. I mean, this is a complicated case. This is not your normal, somebody didn't follow the trust account rules. These are very convoluted, you know, very complex cases that extend over probably, 8 or 10 years. So I'm not going to, again, I don't want to get into the timeliness issue of these things. I want to follow when the complaint was filed and what the rule provides.
If I could continue, and I certainly wasn't meaning to suggest he's going to say each and everything, but one of the things that happened was, in terms of the initial complaint filed by, I guess you'd say, Mr. X, the initial complaint, there's a 38-page response, page in line to all of that. It isn't like this was just ignored. And I think the suggestion we all start September, that's not really right. We really start the prior time when the complaint was filed. I also want to, as far as this implied waiver issue or what was filed on behalf of the board, and I agree, the commission chair people are basically acting as ALJs essentially at these hearings, and they weren't part of this discussion. But I do know what Mr. Harms filed, and basically that got this ball in front of the commission president. He basically says the commission should modify its scheduling order to accommodate Ms. Doe's medical condition, if we could strike that, Doe's medical condition, and the board's need for an answer responsive to the complaint and for Doe's discovery responses to permit reasonable trial preparation for a 3-day trial beginning on March 29. That's at appendix page 840. That's kind of where we were marching in. And in terms of, that's a reasonable interpretation of where the parties were on that issue as they were presenting the case for any panel or any panel president. And the suggestion that that was never discussed is obviously waylaid, really, by this very pleading filed by board counsel. So in terms of the old boy network, as we say, I don't think it's any old boy network at all. I looked at the cases that have construed 36-7 in a very strict way. These were pro se lawyers. It's hard for me to believe that somebody would act pro se when their license is at stake, but apparently you all would see that probably more often than you want to believe. And that's how the rule was applied. There was no one there to make up make any contact with the board or provide any documents, and these are people that just stonewalled the entire process. That is not what happened here. This was not stonewalled at all, and I do think the medical condition of the respondent, Doe, is very material and very important and actually had a lot to do with everything that's happened here.
Counsel, in a lot of civil cases, we've said we disfavor defaults and favor resolution of complaints on the merits. Should we look to those cases for guidance?
No, absolutely. I mean, the reality is, if you're talking bet the company, or however the nomenclature is in different things, bet the career. I mean, what would be more critical for any individual than their entire career, not a liability suit? Yes, the answer is, of course. Trial on the merits, I believe, overall, is the way to resolve any dispute. I think that's been the history of this court, which has looked to have cases resolved on the merits and not on technicalities.
Going forward, let's say we buy your argument. Going forward, what would be wrong with requiring respondents to file an answer with 20 days or file a motion for extension?
Nothing. And it seems to me, based on the history and the firewall that I've just come through to actually stand here and make this argument, I don't think anything. As a matter of fact, after we got the rulings, and after, at that point, we weren't certain whether the interlocutory would be granted or not. We'd made the interlocutory. We filed an answer with the idea that we weren't sure if we were ever going to be in a position to present anything. And there was a motion to strike, which was sustained, and then it was later withdrawn after the interlocutory was granted.
But a pronouncement by this court would make it clear that's what you're supposed to do.
It'd make it very clear. Yes, it would.
And is it that hard to do? I mean, you represent these people. Is that hard to do, to file an answer and ask for an extension?
Well, as a general rule, no. But in this case, in terms of his situation being able to impact and being able to go forward, I believed in talking to counsel and also in talking to Wendell, successor counsel. I thought we'd really covered that. But did I put it in writing? I didn't. Is it that hard to do? No. Will I obviously do it from this day forward? Absolutely. But I've really never had, and this isn't old boy network, whether it was Norm, whether it was Charlie, or whether it's, I think, current board counsel is in the back of the room with some other associates. The reality is I've never had an issue with any of them in terms of scheduling, and I don't call that old boy. I just call that communication between counsel. And then when one goes to hearings, the hearings are presented, whatever objections are made, exhibits are made, the respondent comes in, they're not taking the Fifth Amendment, they answer each and every question from board chairs and the other members. You have a full transcript for a de novo review as to whether or not this charge is valid or isn't. Some of them might be, some of them might not be, and actually there might not be a basis for discipline at all. That's the kind of record that I would hope we can make with this case. So nothing would prevent that.
Thank you, Mr. Brown. The case is now then submitted, and we'll hear the arguments in State versus Pettijohn.